Compelling talk you can count on. This is the Mildred Gaddis Show on News Talk AM 1200 and 99.9 FM WCHB.
This young woman's family learns new details of her tragic death, but the more they find out, the more upset they're getting. On the edge tonight, a woman shot dead, her body dumped, her family devastated. But now police say it may have been just a tragic mistake. They say that someone killed her because they thought she was a criminal. Fox News' Andrea Eisel live now in Dearborn Heights with more. Andrea?
I'm going to read you a sentence from the press release issued to us from the Dearborn Heights Police. And it says, a 19-year-old Detroit woman was fatally shot while standing on the front porch of the home. With that being said, her family says this was no accident. This was not self-defense because they say they were not told that she did anything wrong at all. They want the man responsible, the shooter, the killer, to pay because right now they believe he's getting away with murder.
It's 16 past the hour, and ladies and gentlemen, the law firm representing Miss McBride's family is the Thurswell law firm. Let me tell you about the leader of that firm. Attorney Gerald Thurswell has been honored as one of the best lawyers in America by the oldest and most respected peer review publication in the legal profession. He's highly regarded as an expert in medical malpractice, birth injury, auto accident litigation, and police misconduct. He has obtained numerous multi-million-dollar jury verdicts and settlements for injured people in courts throughout Michigan, as well as other states in this country. He is a past president of the Association of Trial Lawyers in America. He is recognized by the $1 Million Advocates Forum, an organization limited to the most prestigious groups of trial lawyers in the country that have achieved several multi-million-dollar verdicts and settlements. And before we conclude our interview with Attorney Thurswell, we're going to also share with you that the law firm has the capacity to deal with people with the various languages so that there are no barriers. The Michigan Supreme Court is zeroing in on jury instructions in the case of Theodore Wafer, who is the man who was convicted of second-degree murder in the death of Renisha McBride. Attorney Gerald Thurswell, let me say Happy New Year. How are you?
Good. Happy New Year to you too, Mildred.
Good to talk with you again. And tell us what this is about and what does it mean or what could it mean?
Okay. The Michigan Supreme Court has asked the prosecutor and Theodore Wafer's attorneys to brief an issue as to whether or not the court gave the proper jury instructions. Wafer claimed at the time of trial that this killing was self-defense, and the court gave a jury instruction describing what self-defense means, and that is Wafer must have honestly and reasonably believed that his life was in danger of being killed, that his life was in danger of being killed or seriously injured when he shot Renisha McBride. He had to prove that there was a reasonable belief. The court gave that instruction, and the jury heard all the evidence and said that he did not act in self-defense. Wafer's lawyers say that there should have been another instruction given to the jury, and that instruction is that if you reasonably and honestly believe that someone is breaking into your home, if you reasonably and honestly believe that, the jury must presume that Wafer had an honest and reasonable belief that imminent death or great bodily harm could occur and that he could shoot her. The court said that the facts presented in the case did not warrant such an instruction, that there was no basis for him to reasonably believe that Renisha McBride was breaking into his house. If you'll recall the evidence that was presented at the time of trial, Renisha Bernicia McBride was knocking on the front door. If you're breaking into somebody's house, you don't knock. But separate from that, the front door was locked. Wafer got his shotgun, opened the door. He opened the door, saw her, and then blew off her head. There was no evidence that she was breaking into his house at all. No evidence. And the door opened only because Wafer decided to open the unlocked door and blow her head off. So the Supreme Court wants to know if Wafer has any evidence that was presented at trial that could have caused the court to give that instruction. That instruction meaning that he reasonably believed that she was breaking into the house. And I don't think there was any evidence at the time of trial for that. She was knocking on the door. There was no evidence that the door was being broken into, that she was prying the door open, that she was breaking in any way, shape, or form. And that's why the court refused to give that instruction. But the court did give the other instruction regarding self-defense, that if they believe he was acting in self-defense, then the killing would have been justified. So,
how high, Attorney Gerald Thurswell, is that bar? As I heard you explain that, it seemed to be pretty cut and dried. When you share with us that she knocked on the door, she was not kicking in the door, she didn't have anything in her hand trying to break in, that she knocked on the door, and he willingly unlocked that door. She was never inside his home, I don't think. How high is this bar that the defense attorneys are trying to get a hold of?
I was there through the entire trial. I heard all the evidence. The judge heard all the evidence. The bar is low in that if there was evidence that he could reasonably and honestly believe that she was breaking in, the court would have to give the instruction. But there was no evidence that she was trying to break in. Anytime somebody knocks on your door, that's not breaking into your house. That's not breaking in at all. There has to be some type of act that would cause you to reasonably and honestly believe somebody was breaking in. If you knock on somebody's door, that's not breaking into somebody's house. And then you just said it. You said it accurately, Mildred. He was the one who opened the door that was locked, and he was the one who saw her. She had no weapon, and then he blew her head off.
When I
don't think the Supreme Court's going to give him a new trial on that and say that instruction should have been given.
When I heard that was before the state Supreme Court, I was surprised, because I thought that once the jury had ruled and there had been no indication during the trial, I mean, that's when you fight for your client and you bring forth evidence to support the position that you've taken. I was surprised. I was just surprised to hear that the Supreme Court was looking at that.
Well, what really happened was they took this same argument to the Michigan Court of Appeals. The Michigan Court of Appeals said that instruction should not have been given and the conviction stands. That's what the Michigan Supreme Court said. So then they filed an appeal to the Michigan Supreme Court. Now, the Michigan Supreme Court has not even agreed to hear the appeal. They just want both parties to present some evidence to support their position. That is, Wafer would have to present evidence that was presented at trial. He can't come up with new evidence. He has to show that evidence was presented at trial that would support the proposition that he honestly and reasonably believed that she was breaking into the house. He can't present other evidence. And you accurately said what the evidence was. I repeated it. There really is no evidence. So I don't think the Supreme Court is going to grant an appeal. They just want the parties to show if there was any evidence on that issue.
How soon, I know when it comes to legal matters and court matters, we don't know. The clock is a different kind of clock that the rest of us operate by. But how much time do you think the Supreme Court is going to take to yay or nay this?
Probably 6 months or more. Probably. approximately 6 months. The parties have to file their briefs on this issue as to whether or not the evidence was presented at trial. I think they have 30 or 40 days from today left to file briefs on that issue. So that would be done in 30 to 40 days, which is a month, month and a half. And then the Supreme Court has to review that among so many other cases. So they'll probably get to it probably within 6 months, probably sometime this summer.
Well, we'll wait around and see what's happening there. I just want to ask you a couple of questions, and I just got a question from one of my listeners on Facebook. But first, one of the things, the aspects of the Thurswell Law Firm is that you have people on staff, attorneys on staff, who are fluent in English, Spanish, Albanian, Arabic, and Chaldean.
Correct.
Is that generally a problem sometimes for people who have needs, who need to talk with an attorney? Are there generally barriers there, and as a result of that, people just get frustrated or they feel overwhelmed and they don't get their needs met?
Well, in order for us to properly handle the case, we have to know what the client knows. And if you don't have somebody who speaks their language, we can't get all the information, all the evidence that they have. So it's imperative that we have people that speak their language so we can understand what they're saying and we can present our case with full knowledge of the case. We don't want to go in with 60% of the evidence. We want to go in with 100% of the evidence. So you need people that can communicate in their language.
The question that I received on Facebook was this: please ask Attorney Thurswell if the Thurswell Law Firm deals with Social Security disability claims. I have attempted to do this on my own with no success, and I am legitimately disabled.
We have one lawyer who does nothing but Social Security disability claims.
Let me ask you this. What kind of individual legitimately qualifies to file a Social Security disability claim?
They have to be unable to work. They have to be unable to be gainfully employed. It depends. It all depends on what the injury is. Something that's very interesting is sometimes people have an injury requiring them to take certain types of medication just to get around. And it's the medication and the side effects of the medication on top of the underlying condition that then results in a case of disability, because the medication has such side effects. So that's one thing. The other thing is sometimes, and you talked about the language barrier, sometimes people who have a disability, a physical disability, and then they have some type of language problem, if they only speak this language or that language, it's very difficult for them to get a job. So you take the disability and then you add the language problem, they can sometimes qualify. So, but you have to be disabled from performing just about any job.
Well, hopefully that has answered our the question from one of our listeners.
It doesn't cost anything if they call here, and we'll talk to them and get all the details, and we'll do whatever we can for them.
That number, people, to the Thurswell Law First, I'm going to give you an 800 number, and then I'm going to give you a local number, but it's all local to tell you the truth. The number is to the Thurswell Law Firm is 866-354-5544. That's 866-354-5544. The other number, ladies and gentlemen, is 248-292-3355. That's 24.
No. The number is 248-354-2222. 248-354-2222 is the best number to reach us at.
Okay, that number once again is 248-354-2222. 248-354-2222. 2222. I always ask you to go through this drill because I think it's so important, Attorney Thurswell. If people find themselves in a situation as it relates to police, what should they or what shouldn't they do? And how soon do they get an attorney?
Okay, well, let's start from the beginning. It's in the beginning, you cooperate when they're questioning you in the sense not to antagonize. But there's no reason to talk. There is no reason to talk. If they're questioning you about a potential crime, there's no reason to talk. I want my lawyer. I want to talk to a lawyer. There is no reason to talk. Zero. You don't have to give them any information. Your name, your address, driver's license. You don't have to talk about the facts of what happened or what you were doing. Zero. God forbid that you are injured by any law enforcement. You should call us at once. We have cases here in the office where people get arrested. Somehow or other, the system failed, and they're arrested for a crime. They've got the wrong person. The person spends 2 or 3 days in jail, and then they let them go. Oh, I'm sorry, we have the wrong guy. Anytime you think there's been any type of police misconduct, call us. You know that we've handled, and we're handling now, the major cases where individuals have been shot and killed by the police. We have one case right now, the Kevin Matthews case, where the Dearborn Police Department
Yes.
killed this young man. He had some. He was learning disabled. He was unarmed, and I think they shot him 13 times. 13 times.
And they knew him. That was what's so amazing. They knew this. They knew this young man.
You remember the case? They
Yes.
knew him. They knew him. They knew he was learning disabled. They knew him. God, you have a good memory.
These cases are so important to me, and I tell you why. Because we live in a country where we generally trust police, but we live in a country where we have seen, especially over the last decade, thank God to video cameras and all this other stuff, we've seen police abuse their power. And we've seen too many unarmed people die at the hands of police. So I really watch closely and study these cases. Now, this was a case where the police department knew the young man. They knew he had mental challenges. And he was, yet and still, he was shot dead.
Yeah.
Just most unfortunate.
Look at the child. Look at the kid that we represented when the Northland security guards sat on him, and he was crying out, "I can't breathe," called 911, and they sat on him until he died. You put a badge on somebody, you put a uniform on somebody, and many times they exceed their powers and they use excessive force that's not needed and results in death or disability. Just a simple case where the guy spends 3 or 4 days in jail because they arrested the wrong guy.
Yeah. Out in Northland, you're right. You handled the Mackenzie Cochran case.
That's
Mackenzie Cochran was saying, "I can't breathe," and I think there was someone in the surroundings there in the mall saying it as well. And so it's you just never know. You never know. Most of us, live our lives trying to do the right thing, going through our daily chores. You don't know when you could become a victim, or your son, your brother, your husband, your father. We're in an era now in this country where the president says he's not going to police the police. He's been asked, what are you going to do about these killings? I mean, that should not be occurring. And he says, I'm not going to police. I'm not interested in policing the police, which says to me, that there's a tone that's being set here, and we need to brace ourselves and get ready for more of these incidents. So let me give you once again that number to the Thurswell Law Firm. It's 248-354-2222. 248-354-2222. What do you want to leave us with, Attorney Gerald Thurswell?
Well, I want to go back to what you were saying about the police misconduct. 99 and 9/10 of all officers do the right thing. But we have to have better psychological testing before they give these people guns and put them out on the street. And maybe they should have periodic psychological testing before they give them a gun and put them out on the street. So that's my last thought today.
All right, and I thank you so much. Good talking with you. We'll talk soon.
You're very good. Have a great day.
Okay, you too. Bye-bye.
Your station for news talk in Detroit now is your station for smooth jazz